So added value. The majority of the documentation is what generally is a combination of a shareholders agreement and articles of association, though under certain circumstances, potentially just articles will be sufficient. It really does depend on the company. But it's an opportunity to really get the most out of the deal. On the one hand, it's an opportunity to start working together. If it's relatively easy to negotiate with an investor what terms and conditions are going to go into the documentation, it should be relatively easy to work with that investor once they've backed you, put money into your business and really become a partner in your business. It's an opportunity for you to drill down into detail, and this is why modern lawyers can help you, because they want to bespoke a document individually for your needs, to look at the pressure points that investors and investees are coming across, and to deal with those now, to legislate for them up front, and consequently you get this real informed meeting of the minds. If, after really detailed negotiation, you're going to move ahead, it will be the right deal. It will be on terms that you're happy with, and it will be with an investor that is happy to invest in you, in your company, on those terms. Equally, an unequal understanding can be quite divisive. If you find yourself having rushed through the documentation, simply got the check, working in an environment when you've signed up to it, and the investors playing by the letter of the documentation, they were well advised, they understood what it was that they were signing up for, and you simply didn't, you'll be left with a number of questions suggesting, well, I don't think we agreed that. But plainly it'll be there in the documentation, and it will start to break down that all-important, crucial partnership between you and your investor, simply because you didn't engage fully enough and your advisor didn't help you engage fully enough with the process in order to get the best out of it. Warranties is another case in point. Traditionally, it's an opportunity to beat the founders up and to put risk at their door. But in the modern world, it's also an opportunity to look at what's key between the parties, to cut those down to what's really relevant and significant, and for the parties to work out how they're going to deal with those things, and with the warrantor party, the investor, giving the sort of protection that's relevant with the sort of limitations on that protection so it doesn't hang over them or hang round their neck like a millstone. Also, very good documentation that goes into significant detail will give very clear clarity on the roles and responsibilities, both of the management team and of the investors, particularly at angel level, where the angels will no doubt provide significant assistance as well. And my litigation colleagues tell me that it's the #1 litigated area where there is simply a misunderstanding about who's going to do what. And it breaks down that relationship. And unfortunately, it ends up either in the courtroom or with a company that isn't as successful as it could do. Other relevant points to be considered when looking at a shareholders agreement and how really to take that further can fall under two heads. It's all about working together in an informed, engaged area. So, for example, you'll go into some quite significant detail about how this business is going to be run, who's going to be on the board, who will have what decisions, how will the information be passed out to shareholders and to directors. But the reason you'd do that and the reason you'd engage in the process is you will be creating a very simple problem-solving mechanic if things start to get a bit difficult, where you know where you are through that mechanic the whole time. You will be creating a mechanic which means that you are talking to your investors and your directors very often, and that nips problems in the bud before they can become too large or too hard to deal with, or certainly as well before positions can become entrenched. And then the other point, albeit a slightly traditional one, is if you are going to have onerous provisions in there as a deterrent effect, they simply won't have any deterrent effect unless you engage in the process and you know how onerous those terms would be if they are later enacted against you. So it's all about engagement and how good quality legal advice can help you get the most out of the process and make the deal work. And so in conclusion, I'd just like to sum up and say that not having an agreement or not engaging in the process at all is simply asking for trouble. Having an agreement, negotiating a document, and having something bespoke for you is not a box-ticking exercise. It's an opportunity for you to set your partnership with your investor off on the best footing that it can possibly have. And in itself, it has intrinsic value. It has an opportunity to help you take your business with your investor where you would like to take it. Thank you.